This is a review of BLLE Chapter 6, Criminal Law. After reading the chapter, we should be able to explain how criminal law differs from civil law, categorize the various types of crimes, discuss and question the criminal intent of a corporation, and explain basic criminal procedure and rights of a criminal defendant. Crime is an action or omission that constitutes an offense that may be prosecuted by the state or federal government and is punishable by law. It includes a wide range of prescribed conduct, including insider trading, fraud, organized criminal activities, embezzlement, arson, tax evasion, and Ponzi schemes. While going through the contents of this chapter, keep in mind the differences between criminal law and civil law that we've covered in previous chapters. Criminal law has a basis in common law but has been modified and defined by legislatures and statutes. Because citizens have to have notice of what is criminally prohibited, criminal law cannot be ex post facto or vague, as that will violate due process guarantees. Also, because the nature of a crime is that it's a wrong against society, parties cannot agree to forget that a crime occurred if the government prosecutes. However, prosecutors have the discretion to decide what charges they pursue. A broad classification scheme for criminal conduct is type. All crimes fall within either of these two categories. It is either a felony or a misdemeanor. Felonies are punishable by 1 year or more of incarceration or by death in capital crimes. Misdemeanors are punishable by less than 1 year of incarceration. Anything that is not a felony falls within the misdemeanor classification. Crimes may also be classified by the object of the offense. Offenses against the person are enumerated here. The three categories of offenses against the person we will discuss are assaults, batteries, and homicide. An assault is either an attempt to commit a battery or the intentional creation, other than by mere words, of a reasonable apprehension in the mind of the victim of imminent bodily harm. Many states include that the criminal have the present or apparent ability to effectuate the harm that the victim fears. Battery is the unlawful application of force to the person of another that results in either bodily injury or an offensive touching. Simple battery is a misdemeanor. Battery can be intentional, but that is not necessary. Force does not need to be applied directly. For example, causing a dog to attack the victim constitutes battery. There is a jurisdictional split on whether consent is a defense to battery. Aggravated battery is when battery is done with a deadly weapon or results in serious bodily harm or to a child, woman, or police officer. Lastly, we have homicide. At common law, there are three types of homicide: murder, voluntary manslaughter, and involuntary manslaughter. At common law, murder is the unlawful killing of a human being with malice aforethought. Malice aforethought speaks to the criminal state of mind and includes the following: intent to kill, intent to inflict great bodily injury, reckless indifference to an unjustifiably risk of human life, or the intent to commit a felony. Next, at common law, we have voluntary manslaughter, which is murder but with adequate provocation, which is provocation that would arouse the sudden and intense passion in the mind of an ordinary person, causing them to lose self-control. Examples of this would be exposure to a threat of deadly force or finding your spouse in bed with another. Here, the defendant in fact was provoked, but there cannot be sufficient time between the provocation and the killing for passions of a reasonable person to cool. Then we have involuntary manslaughter, which is the killing with criminal negligence or recklessness under the Model Penal Code, or in some states during the commission of an unlawful act. In many states with statutory modifications to common law homicides, murder is defined as being either first-degree, second-degree, or first-degree felony murder. Second-degree murder is similar to common law murder. First-degree murder is defined as second-degree murder with deliberation and premeditation or by specified means. And felony murder is the killing committed during the commission of all or some of an enumerated felony, which also applies to accomplices. Another classification of crimes would be offenses against property. First, we have theft. Under theft, we have a larceny. A larceny is the unlawful taking and carrying away of the personal property of another with the intent to steal the same or permanently deprive that person of the property. So, for example, if a man is walking through an orchard and plucks an orange from a tree and eats it, he is not guilty of a larceny because he has not taken away personal property. But if that orange was on the ground and he picked it up, then it would be larceny. Then we have robbery, which is larceny using violence or intimidation. Embezzlement is criminal conversion and is defined as the fraudulent appropriation of property that belongs to someone else and has been entrusted to the defendant with the intent to so deprive the owner of the property or its use. For example, if we have an employee at a valet parking lot in an airport and that employee lends one of the parked cars to his son who needs to use the transportation for a job interview and later returns it, that would be an example of embezzlement. Lastly, under theft, we have false pretenses, which is obtaining title to property of another by means of materially false representations of fact made with knowledge of their falsity and with the intent to defraud. The fact relates to a past event or existing fact. It does not relate to statements of intention. Also, false pretenses is not mail fraud, and there is no requirement that the victim actually be defrauded. Next, we have offenses against habitation and other offenses. First, there's burglary. At common law, burglary is the breaking and entering of a dwelling of another in the nighttime with the intent to commit a felony therein. However, modernly, by statute, burglary is defined by the entry into a building with the intent to commit a felony therein. Arson at common law is the malicious burning of another person's dwelling. However, modernly, by statute, it's the intention to burn any building. It doesn't matter whether or not it's a dwelling. Then we have bribery. Bribery is the corrupt payment or receipt of such payment for official action. The payment can be in either cash, goods, intangibles, services, or anything of value. At common law, only a public official could be bribed. However, modernly, anyone in a public function can be bribed. Bribing a public official within a foreign country to win a contract would be a violation of the Foreign Corrupt Practices Act. Lastly, we have perjury, which is giving material false oath, whether oral or written, in a judicial or other official proceeding. The oath must be made corruptly with knowledge that it was false or without the sincere belief that it was true. Innocent mistake is not perjury. If the statement is true, then it is perjury if the maker believes it to be false. It is not sufficient to say, I don't know, I don't remember, or to the best of my knowledge. Our next classification of crimes are white-collar crimes, which are fraud-related crimes carried out in a nonviolent way, usually in connection to business. Most white-collar crimes are violation of state law. However, depending on how they are carried out, the offense can also be a violation of federal law. White-collar crimes include embezzlement, tax fraud, price fixing, computer fraud, corporate bribery of foreign companies, violations of food, drug, and environmental laws, and buying and selling of securities that violate securities laws. Our first white-collar crime is mail and wire fraud, which is defined as the act of fraud in which the United States Postal Service or any interstate electronic communications medium is used for the purpose of furthering a scheme or artifice to defraud. This bans the attempts to defraud as well. It does not require that the plaintiff show the scheme worked or that anyone actually suffered losses. Next, we have violations of antitrust law. These affect business enterprises civilly. Antitrust law condemns the activities in restraint of trade. It includes acts like the Sherman Act, Clayton Act, and the Federal Trade Commission Act of 1914. Collectively, these acts prohibit contracts, combinations, and conspiracies in the restraint of trade and monopolization. They also deal with specific restraints including executive dealing arrangements, price discrimination, and mergers and acquisitions. Next, we have violations of Food and Drug Act, which prohibits any person or corporation from sending into interstate commerce any adulterated or misbranded food, drug, or cosmetic or related device. Willfulness or deliberate misconduct is not an actual element to this violation. Our fourth type of white-collar crimes are environmental crimes. Environmental crimes are defined by state and federal legislatures. Many of them also have criminal provisions and include the Federal Water Pollution Control Act, the Clean Air Act, and the Toxic Substances Control Act. Our fifth type of white-collar crime are violations of the Foreign Corrupt Practices Act. This act imposes stringent requirements that the disposition of assets be accurately and fairly accounted for in a company's books and records. Payment of bribes to foreign officials or to anyone who will transmit money to a foreign official to assist the payer in getting some business is illegal. Next, we have violations of the Racketeer Influenced and Corrupt Organizations Act, also known as RICO. RICO attempts to end organized crime infiltration into legitimate businesses. This act tells the courts to construe its language broadly in order to effectuate its remedial purpose. Even if an organization is not a part of organized crime, it can still be convicted of a RICO violation. It bans patterns of racketeering, a commission of at least 2 acts within 10 years of other crimes. Lastly, for white-collar crime, we have computer crime, also known as cybercrime. There are multiple categories of cybercrime, including theft of money, financial instruments, or property, the misappropriation of computer time, theft of programs, and illegal acquisition of information. The computer crimes are enumerated in the Computer Fraud and Abuse Act. Congress has prohibited computer fraud and the abuse where there was some federal interest at stake. There are 2 essential elements of a criminal act. First, mens rea, and second, actus rea. Mens rea is the mental element of a crime and is defined as the intention or knowledge of wrongdoing that constitutes part of a crime as opposed to the action or conduct of the accused. This refers to what the accused individual was thinking and what their intent was at the time the crime was committed. Let's say, for example, a pedestrian steps off the curb in front of a driver who slams on his brakes in an attempt to stop, but he ends up hitting and killing the pedestrian anyway. Although the driver technically killed the pedestrian, he had no intent to cause harm and therefore no guilty mind. This is considered an accident and not a criminal act because partly the mens rea element is lacking. Depending on the jurisdiction and the crime, the mens rea component of a crime may be either subjective, objective, or no fault. Purposeful mens rea means the conscious object of the actor is to engage in prohibited conduct or to cause the prohibited result. Knowing mens rea is knowing and awareness that their conduct is of a prohibited type or is practically certain to cause a prohibited result. Reckless mens rea is conscious disregard of a substantial and unjustifiable risk that their conduct is prohibited or will cause a prohibited result. Objective mens rea is the gross deviation from the standard of care that a reasonable person would observe under given circumstances. This means either carelessness or negligence. Certain crimes and jurisdictions that have an objective mens rea component would include careless driving, issuing bad checks in some states, and involuntary manslaughter. When a crime has a no-fault mens rea component, it's a crime to do a specific act or cause a certain result without regard to the care exercised. Some examples of this would be the sale of adulterated food, the sale of narcotics without prescription, or the sale of alcoholic beverages to a minor. Usually, these crimes deal with regulatory statutes dealing with health and safety. The second element of a criminal act is the actus reus. This is the wrongful or overt act. These are also all of the non-mental elements of the crime. It includes the physical act that must be performed, the circumstances under which they must be performed, and the consequences of that act. So how do we know when there is an act other than the obvious? So as it relates to attempts to commit the prescribed conduct, they are punishable by law, however not as severely as the completed act itself. To be considered an attempt, the conduct must pass beyond the stage of mere preparation and take an actual step towards perpetrating the crime. Generally, the actor has the specific intent to commit a crime and take some direct action towards its completion, and they fail to complete the crime itself. A crime is incomplete if the defendant either abandoned the commission of the crime after taking steps to commit it, such as arranging for a robbery and procuring a handgun, or if the defendant failed to complete the crime after taking steps to commit it, such as being foiled by an alarm system or a security guard. 37 states rule out factual impossibility as a defense to attempt crime. For example, if a man rapes who he thinks is a drunk, unconscious woman, when in actuality the woman is dead, rape would be a factual impossibility. Legal impossibility is also usually a valid defense. Legal impossibility is when a person thinks they are committing a crime, but the act is really lawful, or when a defendant completes all of their intended acts, but that does not fulfill all of the required elements of a crime. For example, Tom purchases some rims, and later on, he thinks that he may be in receipt of stolen goods. However, the rims really aren't stolen. Thus, it is a legal impossibility that he is in receipt of stolen goods. Conspiracy is a separate offense to work with others toward the commission of a crime. Two or more people combine to carry out an unlawful purpose. This has a broad interpretation. It is not necessary to show that the actions that they took were sufficient to constitute either the crime or the attempt. The plaintiff must show, first, that there is an agreement, and second, that there is a single overt act in furtherance of the conspiracy. Let's say, for example, that 3 people agree to rob a bank. One of them, if they go to the store to purchase a gun to use in the robbery, then all 3 of them can be convicted of conspiracy to commit robbery. The act of any one of the conspirators will be imputed to the other members of the conspiracy. Also, for example, it does not matter that only one of the robbers fires the gun that may kill a guard. All of them can be convicted of murder. Lastly, as it relates to agency and corporations, a person may be guilty if they act through another person. Imputation of guilt is not limited to a conspiracy. In an agency relationship, an agent may be innocent even though he participates in a crime, and the principal must share some intent for the agent's intent to be imputed. For example, an officer of a corporation directs a junior employee to take a certain bag and deliver it to the officer's home. The bag contains money that belongs to the company and the officer wants to keep it. The employee reasonably believes that the officer is entitled to the money. This is not a conspiracy. Here, the officer has committed a larceny because the employee's act is imputed to the officer. Also, a corporation can be guilty of a crime. Guilt of an individual employee may be imputed to the corporation. Antitrust statutes state that a corporation may be convicted and fined for violations by employees. Traditionally, a corporation could not be held criminally liable because a corporation could not possess the requisite criminal intent to commit a crime. However, it is the modern approach that a corporation can be held liable for violations of statutes imposing liability without fault and where the offense is perpetrated by a high corporate officer or the board of directors. The corporation can receive fines as punishment, and as it relates to the officers or the board of directors, they can receive fines or imprisonment. Recall from Chapter 1 that corporations cannot go to jail, but managers and officers can go to jail. If a company can show that it has an ongoing process to root out wrongdoing at all levels of the company, then under federal sentencing guidelines, a judge is allowed to consider these as a major mitigating factor in the fines that the company will have to pay. Even if a defendant is deemed responsible for a criminal act, there may be available defenses or excuses. First, we have mistake of fact, which is the honest and reasonable belief that the conduct is not criminal. Honest mistake of fact negates the requisite criminal intent. To use this defense, the belief must be honestly held, the belief must also be reasonable, and the act wouldn't have been criminal if the facts were as the accused supposed them to have been. Mistakes of law generally are not excuses for criminal conduct, but there are some exceptions to that rule. First, if a statute imposes criminal penalties for action taken without license, and if a government official responsible for issuing licenses formally says that you don't need a license when you really do, then a conviction for violating the statute will not stand. Also, which rarely happens, the excuse applies upon attorney's advice which happens to be contrary to statute. Under entrapment, police are limited in the scope of role-playing criminals. They are permitted to use techniques to detect criminal activity, but they are not permitted to do so to instigate crime. So, for example, if a law enforcement officer provides a person who intends to commit a crime with an opportunity to commit a crime, then there is no entrapment defense. However, if the law enforcement officer provides a person who does not intend to commit a crime with an opportunity, then there is going to be the entrapment defense available. So let's say, for example, a law enforcement officer knocks on the door of an innocent grandma not known to be a drug dealer. And let's say the law enforcement officer persists in his demand that she purchase drugs from him. The law enforcement officer eventually overcomes grandma's will to resist, and let's say that she purchases drugs. A subsequent conviction for purchase and possession of drugs will be overturned on entrapment grounds. Next, we have lack of capacity. At common law, children less than 7 years old lack the requisite capacity to create the mens rea in order to have a criminal act. The age of incapacity varies by state and is usually defined by statutes. However, complete defenses include insanity, mental disease or defect, infants, and children. Defense of person or property is also a defense or excuse to a crime. Individuals may use reasonable force to protect themselves and other individuals and their property. This applies to assault, battery, manslaughter, and maybe murder. In the majority of jurisdictions, deadly force is never reasonable to protect personal property because life is more important than the protection of property. Each state and federal government has criminal procedures for initiating and coordinating criminal prosecutions. Their procedures must be constitutional. The Fourth Amendment protects the right to be free from unreasonable searches and seizures, and it specifies that no warrants shall issue but upon probable cause. This makes probable cause a constitutional requirement that search warrants and arrest warrants be based on probable cause. However, the Constitution does not define it. The Supreme Court has interpreted the Fourth Amendment's use of the word seizure to mean both the seizure of evidence and, in an arrest, the seizure of a person. The court also applied probable cause to searches, seizures, and arrests conducted without a warrant. According to the Supreme Court, probable cause to make an arrest exists when an officer has knowledge of such facts as would lead a reasonable person to believe that a particular individual is committing, has committed, or is about to commit a criminal act. Criminal prosecutions are complex and the procedures vary from state to state. However, in most states, this is the procedure that follows. There is an arrest or a warrant for an arrest. Then there's booking. After that, formal notice of charges are given to the defendant. Then there's a preliminary hearing which determines whether there is probable cause to believe the defendant is the one who committed the crime. After that, there is indictment or information. Then an arraignment. And lastly, a trial. There are constitutional protections for those accused of crimes. The Fourth Amendment states that arrests, searches, seizures, and warrants be supported by probable cause. If there is a violation of the Fourth Amendment, then the exclusionary rule prohibits the introduction of illegally seized evidence. However, there are some instances in which a warrant supported by probable cause is not necessary, which includes hot pursuit, voluntary consent, emergency, lawful arrest, evidence of a crime in plain view, and the delay would present a significant obstacle to the investigation. The Fifth Amendment requires an indictment by a grand jury for capital crimes, prevents double jeopardy, protects against self-incrimination, and prohibits deprivation of life or liberty without due process of law. Double jeopardy means that no person shall be subject for the same offense to be twice put in jeopardy of life or limb. If the defendant is acquitted, then the government cannot appeal. As it relates to self-incrimination, no person shall be compelled in any criminal case to be a witness against himself. Miranda rights must be read only if there is a custodial interrogation. The Sixth Amendment requires that an accused receive a speedy and public trial by an impartial jury. Under the Speedy Trial Act of 1975, that requires all criminal prosecutions go to trial within 75 days. Lastly, the Eighth Amendment prohibits excessive bail, excessive fines, and cruel and unusual punishment. I hope you guys enjoyed this review of BLLE Chapter 6 on criminal law. If you have any questions, please feel free to send me a message in Canvas or just ask me after class.